the next round, first of all, Ms. Wilson-Raybould, you've been sitting here for quite a while. Would you like a break?
I'm okay.
You're okay.
But,
If you're okay,
if we get to
I
9
applaud
o'clock,
you.
I probably will have a different answer.
Please let me know if there is at any point you feel you need a break. So the next round, which would be going back to the way the first round goes, it's 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. Ms. Raitt? Ms. Raitt.
Thank you very much. I don't want to keep going over and over the same grounds, but if I could just summarize, and you can tell me if I've got this right or not. The reality is that for a significant amount of time, from the time you made your first decision to the time in which you were moved into Veterans Affairs, you had upheld the rule of law by withstanding the overtures and the entreaties of various people within the government, within the Privy Council office, within the staffing to the government. And as a result, we can draw the conclusion that your movement, not out of cabinet, but your movement within cabinet was as a result of the fact that you didn't play ball with them and deliver what the Prime Minister wanted, which was a solution for the SNC-Lavalin political issues that he had before him. Is that a fair summation?
I believe that committee members can draw their own conclusions,
Sure.
and I will not comment on conclusions of committee members.
Yeah, that's fair. At the very beginning, I asked you about witnesses that could potentially come forward. Of all the individuals that you have named helpfully and put brackets around, do you believe all of them would be able to give insight into what happened in these certain circumstances? Because there's conversations that they may have had that you weren't privy to that may help illuminate what was going on.
I'll answer it this way. I believe that individuals that I've named in my testimony, having been involved in those conversations or meetings, would have perspective about those meetings. And again, I think the more information that this committee has, and testimony from individuals that were directly involved is important.
So not a trick question, but do you have any knowledge of the friendship and relationship between Ben Chin and the Vice President of Government Relations for SNC-Lavalin? Do you have any knowledge that they go back to the McGuinty government and were great friends there? In fact, their relationship goes back further than their political interaction. Do you have any knowledge of that at all?
I have no knowledge of that.
Do you have any knowledge of the fact that Mr. Butts as well has a long-standing relationship with the VP of Governmental Affairs of SNC-Lavalin? In fact, they two worked together in the McGuinty government in the province of Ontario for a long period of time and probably know each other?
I have no knowledge of that.
Did you think it was odd that the Chief of Staff to the Minister of Finance would be requesting meetings with respect to your authority on deferred prosecution agreements or even in the conduct of criminal prosecutions? Was that a surprise for you?
I was aware of initial conversations that the Chief of Staff to the Minister of Finance had with my Chief of Staff. And I didn't consider it hugely problematic, but the sustained communication I did find problematic, and not sure why anyone from the Minister of Finance, the Ministry of Finance, the Department of Finance would be talking to my chief about something in terms of my role as the Attorney General.
Why do you think that the provision that amended the criminal code regarding deferred prosecution agreements ended up in the budget implementation bill and not in your criminal justice reform bill?
The deferred prosecution agreements and providing an additional tool to prosecutors was something that was being advanced by a number of ministers around the cabinet table, including the Minister of Finance. I, of course, as the Minister of Justice, am responsible for the criminal code, and as such, was part of the documentation and the discussions leading up to and including the introduction of the budget implementation bill with respect to deferred prosecution agreements, because I alone can change the criminal code.
Right. And did your department at the time have any input into the discussions around changing the integrity regime, which was out of Public Works? Was your department involved in that as well?
I can't be precise on the number of conversations that were had, but certainly the Minister Qualtrough was involved in the integrity regime. My department worked with hers around consultations, but the extent of that, I know that it was not a Department of Justice lead.
Yeah.
It was the lead of the PPSC.
Last question that I have for you. Out of all of the lobbying that happened on this, including, admittedly, with our party, SNC went in to talk to everybody, and I believe my colleagues as well were spoken to by SNC. I don't see your name on the list of those who were lobbied. Were there any requests made by the lobbyists of SNC to come in and visit you and talk about the issue of deferred prosecution agreements, given that you're the only one that can change the criminal code?
There was never a request.
Okay, thank you.
Thank you very much. Ms. Sahota?
Ms. Wilson-Raybould, I really do appreciate you emphasizing that our system is intact and there is a lot of integrity in our judicial system. I know that, after today's hearing, there are going to be those concerns raised, and you have testified to that. The clerk of the Privy Council has testified to that. But what I want to get into a little bit is that issue of responsibility that you have in your role as Attorney General. And today, we discussed, I think at some point in November, it seemed like you had, had enough contacts made and your mind was made up. Why, if you felt the issue was so serious, why did you not resign or pick up the phone and really have that serious conversation with the Prime Minister at that point?
Well, I made up my mind in September, and I articulated that to the Prime Minister. I felt no compulsion to resign because I was doing my job as the Attorney General. Okay. I had made a decision around my discretion and exercising it with respect to issuing a directive or taking over a prosecution around SNC and the deferred prosecution agreement.
Okay.
So
how about on January 7th, you said you had a conversation with the Prime Minister about changing your portfolio to Veterans Affairs. Mm-hmm. At that time, did you bring up your concern to the Prime Minister about what you felt the reasoning was for the change?
Yes.
Okay. But you still took on, knowing what you had known and feeling what you had been feeling. If interference was happening, if the pressure was so serious, and you had justified just now that the reason you resigned later on is because, not that you did not have confidence necessarily in the Prime Minister, or you wouldn't put it that way, but you didn't have confidence being at the cabinet table. Why was that decision made then and not at the time of that you were offered Veterans Affairs?
So I can't talk about any further about my resignation or any conversations or how I felt, because that's not covered in the OIC waiver that's been provided to the committee. But I did reflect on, while I was still the Minister of Justice and Attorney General, over beyond December the 19th and up to and including December 14th, about my role, about my concern and my uncertainty around whether or not the government or the incoming Attorney General, and I didn't know who that was at the time, and that's irrelevant, would enter into a deferred prosecution agreement with SNC. And as I said, if I had seen, which is required, a notice in the Gazette around a directive, I would have immediately resigned upon seeing that.
Okay. You bring it up the Saturday Night Massacre. I can bring up, we've had other attorney generals, a specific one in BC, Brian Smith, who faced some challenges. And what they did in their role, they felt their responsibility was to resign at that point. Did you not see it as your responsibility to resign if the issue was so serious?
At the time, I did not see it as my responsibility to resign. I saw myself as the Attorney General of the country who was doing her job to ensure and uphold the independence of the prosecutor and uphold the integrity of the justice system and the rule of law.
Okay. In November 4th, you had your 3-year anniversary of being sworn in. You put up a Twitter post about thanking the Prime Minister and what an honor it is to be in this role. To me, you also posted up your oath of the Privy Council, and within that oath, it said that I will treat all things to be treated, debated, resolved in Privy Council faithfully, honestly, and truly declare my mind and my opinion. Now, this is an oath you took, the Prime Minister also took. So in my mind, when I think about the conversations, I've never been there, around the cabinet table, I would think that as colleagues, you guys will have open discussions about the interests and acting on different files, making decisions, and the Prime Minister would be open and completely honest, just as you would be to him about what was happening. And in this regard, I feel like you had held back in your position, even though the Prime Minister had mentioned on several occasions his concern about the public interest, about the loss of jobs.
I can without equivocation say that I did not hold back as the Attorney General in this case. More broadly than that, as the Attorney General and also as the Minister of Justice, I always felt it appropriate to raise concerns, to engage in discussions and debate, and always speak, as I've said, my truth to power. I did that. In this particular case, I was entirely comfortable on September the 17th questioning the Prime Minister on whether or not he was politically interfering with SNC and DPAs.
And he said no, and so did you believe him at that point? Because on January 14th, you took on a new role as in another ministry.
Well, as I said, I took him at his word. I took him at his word after I directly questioned him in September, and took him at his word after I directly questioned him and Jerry Butts in January. I chose to take them at their words.
And so on January 14th, you also had faith and belief that there was no interference, and that's why you carried on with taking on a new role?
I had serious concerns about it. But again, I took the Prime Minister at his word.
Thank you, Ms. Sohoda. We go to Mr. Cullen, and I just want to advise everyone that the NDP has advised me they have a motion they wish to put forward. After we finish the rounds of questions and we have no more questions, I will allow the NDP representative, Mr. Rankin, to put forward the motion, okay? So, Mr. Cullen, the floor is yours.
Thank you very much, Chair. Thank you, Ms. Wilson-Raybould, for your not only your testimony but your endurance today, as we've gone into some time. It's the directive you talked about. Ms. Raitt questioned about how rare it was and how unique it was. Can you say again that it has never been used in a specific case? Was that your testimony here today, that an Attorney General has never used the specific directive on a specific case, like as in the case of SNC-Lavalin? Is that right?
That's correct.
So not only is this tool incredibly rare, it has never been applied in the way it was being suggested by the Clerk of the Privy Council, all the other people that consistently lobbied you to use that tool. They're asking you to do something essentially historic.
An Attorney General has never issued a specific direction in a specific prosecution, nor has an Attorney General in this country ever issued a directive, taken over a prosecution. Right. It would be historic for the first time. It would be historic.
So what you were being asked for is not only extraordinary in this case, you were being asked to do something unprecedented. Is that fair?
With respect to a specific prosecution,
yes.
Yes.
Yeah, okay. I'm a bit confused by this line of logic that I've heard my Liberal colleagues just recently use, They're questioning essentially, I think, your integrity for not quitting. I thought your integrity was enhanced by not quitting, by staying there and, as you've just said, maintaining the rule of law. What am I finding confusing about this? You should have quit when you were being pressured inappropriately, consistently by some of the most powerful people in this country. You resisted that pressure. You said you were not going to give this plea deal, this special offer, and you stayed in the job. People are questioning your integrity for having taken that course of action. Do you understand my confusion and why Canadians might be confused?
I can say this. I have always acted with integrity, with purpose, and with principle. I was doing that in my role as the Attorney General when it came to SNC and the deferred prosecution agreement potential. I suspect that this committee will have discussions about the testimony and differences of opinions, but I also believe in Canadians and their ability to hear the words that I've spoken, hear the facts that I've expressed, to make their own determinations.
Okay, well, I think many of us are making our own determinations based on what we're hearing today. The ability to seek one of these special, I'm calling them plea deals, I'm not a lawyer, these deferrals, they can't be made for political reasons, is that correct?
That's correct.
It's illegal, in fact, for you to have made the decision based on political motivations, is that correct?
It would be unlawful for me to do that.
It would have been unlawful for you. Is it unlawful for someone to ask you to do that?
To direct me or to ask
Pressure
me?
you? I mean, there's a line that's being contemplated. First, when this story first broke, the Prime Minister said everything is false. And then there was no pressure put. Oh, there was some pressure put. Don't worry, the clerk says it was appropriate pressure. All pressure to do something that we've heard from your testimony today that had political motivations, which would have been against the law for you to do as the Attorney General. Have I said anything wrong to this point?
No.
Okay, good. Is it illegal for someone to pressure the Attorney General to offer a special plea like this for political reasons? Is it illegal for someone just to pressure the Attorney General to intervene on a case?
In my opinion, it's not illegal.
Mm-hmm.
It is very inappropriate depending on the context of the comments made, the nature of the pressure, the specific issues that are raised.
Right.
It's incredibly inappropriate and is an attempt to compromise or to impose upon an independent Attorney General.
So there was pressure put. There was veiled threats you talked about. You repeatedly asked those threats to stop, those communications to stop with you and your office. Is that correct?
That's right.
And it continued. You said, I'm not doing this. I've already made up my mind. You have sound legal reason for your mind. You're upholding the rule of law. And the pressure continued. The veiled threats continued all the way through December. Is that correct?
It continued. I wouldn't say that the veiled threats continued throughout the time frame.
Oh.
There was an escalation in terms of the pressure or the attempts at political interference that culminated in the meeting on December the 19th.
So up until that meeting on December the 19th, starting way back in September, you had given notice, you've made your decision. The decision is already, the train has left the station. You're not going to interfere with the public prosecutor, the independence of the prosecution to do their job and uphold the rule of law. You ask for it to stop. It, in fact, escalates in terms of the pressure. Is that right?
That's correct.
Okay, so an independent, yeah, the independence of the Attorney General's office. I'm just reflecting on the Prime Minister's argument about the importance of the rule of law in Canada when dealing with Huawei, and that the argument consistently made by this Prime Minister was he had no choice because he so believed in the rule of law. At the very same time, he and his staff, his key advisor, and the clerk of the Privy Council, and others in his staff from the finance minister on down, are not respecting the rule of law and your independence as the Attorney General of Canada. I find the contradiction, the hypocrisy of this situation breathtaking. And I've seen a bit from Liberal governments. I thank you, Chair.
Thank you, Mr. Collin. So now we will go to Mr. Sassi.
Thank you, Mr. Chair. Now, my first question is, you had an opportunity to speak to the abilities and the discretion of prosecutors. I want to ask you about the obligations of prosecutors. You're fully aware of the handbook for prosecutors, and those are your duties and expectations that you are passing on to prosecutors. In relevant part of that particular handbook, it says Crown Counsel must continually assess at each stage of the process whether the prosecution is in the public interest. So if they have an obligation to continually reassess, would you mind explaining to us why it's your opinion that when you made your decision on September 16th, it wasn't your obligation also to continually reassess the facts?
I am provided as the Attorney General with notices by way of Section 13 in the Director of Public Prosecutions Act from the Director about issues of general interest. I received, when I was the Attorney General, many of these notices. This is the Director raising, as I said, issues of general interest. And saying that they are providing this information to me at the time as the Attorney General to do as I deem appropriate. I made my decision based on information that I received from the Director of Public Prosecutions by way of that note. I did my due diligence. Again, was firm in the decision that I made. I have never said that it's not within the ability or the job or the discretion of a prosecutor to continue to evaluate the case that they have before them. Of course they can. It's the case in every prosecution. The prosecutor can act based on the circumstances, based on the facts, based on the input that is presented to them. I am not the prosecutor. I have the ability to be notified by the Director of Public Prosecutions by way of Section 13 notices.
Thank you. It would seem to me that that everyone who has this responsibility has an obligation to look at the facts as they change. Now, I had a question about timing. Again, if you could explain to us why you did not bring to anyone's attention your misgivings about the legal process until after you had been appointed to another portfolio.
I'm sorry, I don't understand the question. I am not at liberty to talk about anything after I was no longer the Minister of Justice and the Attorney General. When I was the Minister of Justice and the Attorney General with respect to SNC and deferred prosecution agreements, I did raise my concerns about the inappropriate nature of the interactions that I was having.
And when did you raise this?
From September the 17th through to, including the December 19th meeting, through to the January 7th meeting that I had.
So all your expressions of concern are the ones that you have detailed in your opening statement?
Well, I appreciate actually answering this question because I know that the letter from the chair was for me to come here and give my complete account. I have done my best to give my complete account, but there is, due to time, in terms of my opening statement, I had to confine my comments to certain expressions and meetings and details. That's not to say that it is a complete account of everything that was said, and certainly I have the inability to speak to anything that occurred after January the 14th.
And could you provide us with the basis as to why you think that everything that happened after you were appointed to a new portfolio is actually cannot be waived. What is the obligation that you cite?
I am not going to speak to that. I have received the order in council and the waiver that's been provided to me to speak about matters that would be covered by solicitor-client privilege and cabinet confidences to this committee and to the ethics commissioner for the time that I was the Minister of Justice and the Attorney General of Canada.
And thank you for that.
I guess just I don't want to intervene, but I think that was the question was so that the committee knows just on what basis, and I'm guessing that it's cabinet confidence because you wouldn't have solicitor client after you became Veterans Affairs Minister would be on cabinet confidence, correct? Is that what?
Every conversation that I may or may not have had when I was the Minister of Veterans Affairs with the Prime Minister or not with the Prime Minister, up to and including the meeting that I had with my then colleagues around the cabinet table, would be covered by cabinet confidence.
That's I think what he was trying to get out. Thank you. So we now have a question. Do we move to another round, colleagues? Yes or no? Yes? Yes? Agreed? So this round, first, before I do that, Ms. Wilson-Raybould, do you need a break?
I mean, I'm happy to go another round, but probably after that, I will ask that
But if you need
we
one now-
reconvene at another time, and so we can
Of course.
continue
But
the
if you
discussions.
need one now, I'd be very happy to give you a 10-minute break. Would that be helpful in any way?
Actually, I'd prefer not to have a break.
okay.
I do have to say, and again, I'm happy to answer questions, but the nature of the questions seem to be very similar, and we're continuing to go over the same ground. If they're, and I'm happy to continue to answer those questions, but I just wanted to put that out there. But if there is another round after this one, I would ask the committee that that I be able to come back and answer questions.
I understand, and we'll and the committee will definitely take that into consideration on its decision after this round. But I think we can perhaps look at this being then the last round for today. So this round is 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So, Ms. Khaled? Oui, Monsieur Ford. Oh, oui, excusez-moi. Oui.
Yes, I'm sorry. I promised Mr. Fortin, who'd been at our meetings previously and asked for some time to speak. We gave him 3 minutes after the last round of questions.
Of the committee, do we agree that at the end of this round, that we give 3 minutes to Mr. Fortin, 3 minutes to Ms. May, and 3 minutes to the Cooperative Commonwealth Federation for its first questions in Parliament in 50 years in a committee? Is that okay with everyone? Is that okay with you, Ms. Wilson-Raybould?
Absolutely.
Thank you very much. So we will start with the Conservatives. No, sorry, Liberals. Ms. Khaled, I'm sorry. We're round 6. Ms. Khaled.
Thank you, Chair, and thank you, Ms. Wilson-Raybould. We really do appreciate your patience and you continuing to stay on here, as I'm sure that Canadians have a lot of questions and to get a lot of your truth out. You had mentioned in the meeting with Jessica Prince and the Prime Minister's Principal Secretary and Chief of Staff that when your Chief of Staff left that meeting, she was very upset, and with respect to kind of understanding what that was and what measures could have been taken at that point. The clerk said also, Mr. Wernick, that in his testimony he'd listed out some of the remedies that were available. He talked about going to the Prime Minister and speaking and having that tough conversation with the Prime Minister. He talked about picking up the phone and calling the Ethics Commissioner, and he said ultimately as a last resort resigning. And I don't think anybody expected you to resign, but we're just trying to understand kind of the context and how you were feeling as you were going through all of this. So earlier in my questions to you, I had asked if you had spoken to the Prime Minister from your September 17th meeting going up to the time when he spoke to you with respect to your new appointment. My question really is, why didn't you speak to the Prime Minister during all of that, as all of this was building up, as you've indicated, as all of these things were happening? Why did you not speak to the Prime Minister? Why did you not call the Ethics Commissioner? You are concerned, and as you rightly should be, about the rule of law. Why didn't you take any of those measures? It didn't have to be to the point of resignation.
Well, I won't deal with it to the point of resignation. But again, I did raise this with the Prime Minister directly on September the 17th. And from that point through to and including December the 19th, there was a sustained and continued attempt to politically interfere. Those meetings consisted of many people within the Prime Minister's office, including the Principal Secretary to the Prime Minister and the Chief of Staff, in reference to the meeting that you talked about with my Chief of Staff, then Chief of Staff, Jessica Prince. Yes, she was upset when she came out of that meeting because of the continued and escalating pressure and interference that was placed on her to relay back to me as her minister from the Principal Secretary and the Chief of Staff. Those conversations included the Principal Secretary saying that this situation would not be resolved without some kind of interference. And the other statements from that meeting are contained within my opening testimony. It was my understanding, after I had had the opportunity to speak with my then Chief of Staff, that there would be potentially a meeting or a call the next day, because I was in Vancouver, with the Clerk of the Privy Council and the Prime Minister. So I was waiting to get a call from the Clerk and or the Prime Minister. That call happened with the Clerk, who invoked the Prime Minister's name throughout the entirety of the conversation. That call ended. The next discussion that I had, and everybody was going on holidays, I was confident in the knowledge that there would not be any interference with the discretion, because I was the Attorney General and I'd made my decision. We all went on holidays. The next conversation that I had was on January the 7th with the Prime Minister, where I raised this issue.
You've been able to reach out to the Prime Minister in the past, but I still don't understand why you didn't reach out to him when this was such an important issue. It was not raised with the Ethics Commissioner either. But please pardon me, I have not been able to get clarity on this. I just want to flip to one other thing that we have spoken about today, and it is with respect to remediation agreements, which my colleagues have addressed at length. Do you agree with remediation agreements in principle?
I was part of a cabinet that brought in the additional tool to prosecutors that they could utilize, and that tool was deferred prosecution agreements.
So you do agree with deferred prosecution agreements in principle?
I do not believe that my personal opinion on deferred prosecution agreements is relevant.
Well, I think with the scope of the motion, it may be relevant for us to consider. The motion? The whole reason that why we're here today with the motion, speaking specifically to understanding the nature of remediation agreements, of deferred prosecutions, etc. And I do believe that you had voted in favor of deferred prosecution agreements as part of the budget bill.
Well, that's clear. I already said that I did. I was part of a cabinet that brought this tool in, and Parliament passed the legislation, and the criminal code was amended in September of 2018. I would submit that discussions around deferred prosecution agreements are irrelevant to this discussion. What is relevant to this discussion, and that's the discussion that we've been having now for some time, is the role of the Director of Public Prosecutions, the role of the Attorney General of Canada, and the necessary independence that is a constitutional principle for prosecutors to be upheld. I believe that is the relevancy of this discussion, not whether I agree or disagree, or any member of this committee agrees or disagrees with the tool of deferred prosecution agreements.
Thanks for clarifying that, Ms. Wilson-Raybould.
Very much. Mr. Barrett?
Ms. Wilson-Raybould, thank you very much for your extended testimony with the committee. Is it your assessment that the Prime Minister has been accurate and truthful in his statements concerning this issue?
I'm not going to comment on statements of the Prime Minister or anyone else as to their validity.
Okay. And Mr. Chair, we'll cede the rest of our time. Thank you.
Thank you very much. If the Conservatives are ceding the rest of their time, that goes back to the Liberals. Who is up? Mr. Boissonneau.
Thank you very much, Mr. Chair. Madame Raybould, j'ai une question pour vous en français.
Ms. Raybould, I have a question for you in French. In your role as Attorney General, have you ever, when you were Attorney General, did you ever receive advice from sources outside of government, lawyers, attorneys, from outside with regard to Canadian law or bills?
Minister of Justice and the Attorney General of Canada, I have received advice from external lawyers. I have taken it upon myself to foster relationships with previous Ministers of Justice and Attorney Generals of Canada. I, again, feel it's very important to have a diversity of views about particular issues, and I welcome feedback from individuals, particularly where it has to do with putting forward legislation and changing the criminal code, for example.
Thank you very much. You mentioned in the document at the beginning of this session, your testimony, that you conducted a period of due diligence. Could you share with us who you conducted due diligence with in this SNC-Lavalin matter?
I don't feel it's appropriate to share that.
But it's the privilege has been waived, and so is cabinet confidence. So who did you consult with?
Why I don't feel it's appropriate to answer that question is because it gets into discussions around the nature and the content of the Section 13 notice that was provided to me as the Attorney General from the Director of Public Prosecutions, gets into topics that are right now before the courts.
Okay, but back to my earlier line of questioning, which was this issue of, the openness to receiving new information and making sure that there is never a final decision. Let's look at this a different way. What is the number of individuals that you consulted with during the due diligence before you came to what you have told us is your final decision, even though the law permitted you to continue to look at having a deferred prosecution agreement? And you have said very clearly that the principles of law indicate that you need to have an open mind before there is a final decision. And in fact, it can't ever be a final decision. So how many individuals did you consult with in your due diligence?
Well, actually,
Sorry to interrupt. With apologies to Mr. Boissonneau.
Stop the time.
There was a question raised specifically about external references. The witness, Ms. Wilson-Raybould, said because it's sub judice, it's before the courts, she was unable to comment on it. And Mr. Boissonneau continued. We've heard. This is a totally different matter. Totally different line. Now you're asking for numbers. You're asking for specific.
The issue of external.
I'm not actually addressing
guys,
you, Mr. Boissonneau. I'm talking to the chair.
I understand. So let Mr. Collin finish his point, and then I'll.
So when a witness is asked a specific question, and then the question is reframed, but essentially the same question, the witness has already said this is sub judice. We're now 3.5 hours into this meeting. It seems strange to me that an argument that has been used often to prevent witnesses from testifying at this committee, sub judice, the argument, is now being offered up by the witness in front of us, and it's not being accepted. The questioning continues. And oftentimes, as you know, Chair, when a witness says, I'm unwilling or unable to answer a question, we as committee members simply accept it at that.
So a couple of things. I don't recall any witness having been refused to this committee in 3.5 years on the sub judice rule, so that is not correct. With respect to Mr. Boissonneau's question, he's attempting to rephrase the question in a different way. I will alert everybody again that Ms. Wilson-Raybould made the point that the sub judice rule applies to specific questions with respect to SNC-Lavalin, that we do not want to have an impact on the appeal of SNC-Lavalin on their questions of the remediation agreement, and therefore her specific interactions with the Department of Public Prosecution and others within the Department of Justice would not necessarily be, the committee can do what it wants. It's the master of its own domain. Everybody can ask those questions. That's a restraint that we choose to put on ourselves. So there's nothing either unfair of him trying to rephrase his question. I'd encourage him to do it in a different way, or alternatively, for the witness to refuse to answer the question on that basis. And that's where I think we should go. We have 3.5 more minutes on Mr. Boissonneau's testimony, Mr. Boissonneau's questions. Mr. Boissonneau.
Thank you, Mr.
Ms. Wilson-Raybould, if you think he got his question finished, you're more than welcome to answer it.
I will say what I was going to say prior to the discussion of committee members. Mr. Boissonneau, I am not trying to be evasive. I take incredibly seriously my responsibilities as a member of Parliament. And to have conversations about what I did and didn't do around due diligence with respect to a Section 13 notice, I think that with respect, the committee should realize that at the time I was the Attorney General of the country, and which makes me different than anybody else with respect to that circumstance. And it would be very inappropriate for me with respect to go into any of these discussions.
I appreciate that. I appreciate the answer. And my question to you is this. Once you made your final decision, and you mentioned that in your testimony, would you say then that your mind was closed to new information and a new context?
I had made my decision where to not interfere with the decision and discretion of the Director of Public Prosecutions. I was made aware as the Attorney General about general interest prosecutions by way of Section 13 notices from the Director of Public Prosecutions. I had made my decision on this particular matter. That is not to say that the prosecutor in this case or any other case does not continue to work on the case, to take in new information, to have discussions with whomever they deem appropriate throughout the course and the evolution of a prosecution up to and including a potential trial.
Thank you. Can you tell us where you memorialized your decision to not proceed with a deferred prosecution agreement in this matter?
Where I memorialized
Like where you made a memo or indicated that today's the day, we're done, my decision's final. Where would you have recorded that?
Well, this is not a direct answer to your question, but I take copious notes.
So it's in your notes somewhere?
Day. I am faced with many Section 13 notices, or was when I was the Attorney General.
A question for you then is, did the Prime Minister, the clerk, or the PMO ever direct you to enter into a remediation agreement with SNC-Lavalin?
No.
Thank you. Thank you, Mr. Chair.
Thank you very much. We now go to the Conservatives. Mr. Cooper.
Great. Thank you, Mr. Chair, and thank you again, Ms. Wilson-Raybould. A number of members opposite have repeatedly raised the specter of these conversations as somehow being in relation to the public interest and therefore somehow appropriate. And I just want to ask you, are factors such as the Quebec election, finding a solution for SNC, as the Prime Minister stated when you met with him on September 17th, the fact that the Prime Minister is a member of Parliament from Montreal, the fact that SNC-Lavalin's council is not a shrinking violet, or as the clerk of the Privy Council informed you on December 19th, quote, I think he is going to find a way to get it done one way or another. So he is in that kind of mood, and I wanted you to be aware of that. Are any of those things appropriate considerations in exercising your prosecutorial discretion with respect to the public interest?
Those are not appropriate.
Mr. Cooper. Next is Mr. Rankin.
Well, we've been here, Mr. Chair, for now several hours, and I think I'd like to move the motion rather than take the time to do so later. I would not use my time for anything but to make the motion at this point.
The motion, there is no problem. But remember, we had said Mr. Fortin, Mrs. May, and Mr. Weir. So would you like to wait on your motion?
I'd like to move the motion
in
the time allotted to me, and then I'd like to have a vote if there's a need to do so. And then, of course, we'll hear from the others as we've agreed.
Okay. I mean, that's fine with me. You have a right to move a motion within your time. I'm only pointing out that requires the witness then to stay here for those last questions as opposed to liberating
This is a short motion. And it goes like this, Mr. Chair. In the interest of transparency and accountability, I move that the Justice Committee call upon the Prime Minister and the Governor in Council to extend the waiver of solicitor-client privilege and cabinet confidentiality relating to the SNC-Lavalin issue, so that the former Attorney General can inform the Justice Committee of any relevant information with respect to the period subsequent to her ceasing to serve as the Attorney General of Canada on January 14, 2019. In other words, Mr. Chair, we've got to a certain point and we've been told that thereafter we cannot ask questions and the witness cannot tell us what happened. I think the evidence is abundantly clear that we need to know that, and therefore I'm moving that this committee request of the Prime Minister and the Governor in Council that order in Council be altered accordingly.
Thank you very much. What I'd first ask is, does anybody need time to consult and discuss this motion within themselves, or is everybody good to go ahead and debate and vote?
I'd like a recorded vote.
Ms. Khaled?
If it's okay with you, can we just confer amongst our Liberal
That's
colleagues
what I was asking. So
Thank you.
can I ask the question again, Mr. Rankin? You moved the motion. Can we ask the last three questioners to go?
No, that's fine.
And then have just a brief pause for the consultation?
Certainly. I just wanted to get their motion
course.
on the record, and I'm more than happy to consider it a notice of motion, but I would request that we come back to it immediately after the testimony today.
Absolutely. So what I'm suggesting is let's have Mr. Fortin, Madame May, and Mr. Weir get their 3 minutes in. Let the witness be liberated, and then we can come back to this and just have a brief. A brief pause. The word "liberated" is probably not the right word. So thank you very. Who goes? Qui veut aller premier? Monsieur Fortin première, Madame Way.
Mr. Fortin first.
Gela Kessler, I want to ask something that's just very clearly, and then I move to a different line of questioning from what others have been asking. And that is, first of all, do you believe that individually or collectively the pressure to which you were subjected contravened the criminal code?
I don't believe that.
Okay. Mike, there are a lot of power relationships we've been discussing, and most of the questions have gone to the power relationships around political actors, the Chief of Staff, the Principal Secretary, the Prime Minister, your role as both two hats, judicial hat and cabinet hat. But there's a very prominent role being played by, I think, unusual actors in the civil service, where the power relationship is the clerk of the Privy Council is the boss of the Deputy Minister at the Department of Justice, and down through the chain, with you essentially, I think, acting as a bulwark to protect the independence of the Director of Public Prosecutions. What I wanted to go back to in your testimony, there are a couple of places where you mentioned some things, and I wondered if they were concerning to you, and if so, why. So in chronological order, you mentioned that on September 7th, the Deputy Minister was able to have certain sections of the Section 13 notice read aloud to her, but she did not want to receive or be given a copy of it. Was that in any way concerning to you? It's included in your testimony. I just wanted to pursue it.
Yes, that was a concern.
And why were you concerned?
Well, as the Minister, as the Attorney General, I worked very closely not only with my Chief of Staff, but with the Deputy Minister. And this applies to my then deputy minister and the clerk of the Privy Council when public servants get involved in political discussions. Of course, I have concerns, and I believe it's inappropriate.
So going to September 17th, you described the meeting which you had requested of the Prime Minister on a different topic was supposed to be a one-on-one meeting, by which I infer you did not expect the clerk of the Privy Council office to be present when you went to meet with the Prime Minister. Is that correct?
I didn't expect that, but I will say that the fact that he was there, I didn't ask him to leave.
Okay. So in the context of the pressure that was being applied and the political concerns that were being raised, I'm going to put forward a positive statement, see if you agree, that the appropriate role for the clerk of the Privy Council office is to support the Attorney General who says, you're in a dangerous ground here. Back off, this is political interference. The job of the civil service is to remain nonpartisan and give good advice. Did you think the clerk of the Privy Council was behaving appropriately in applying political pressure to anyone in this case?
I did not believe that he was behaving appropriately, which is why I was very surprised when he raised issues of the Quebec election and a board meeting that was supposedly happening with SNC.
Do you believe that the clerk of the Privy Council appeared to be placing your Deputy Minister of Justice under pressure that could have affected her confidence in her job security?
Honestly, I don't believe I can answer that question.
And lastly, you said that you
got to wrap up. That's your you're sort of over your time.
Okay.
Thank you very much. Monsieur Fortin?
Merci.
Thank you. Ms. Wilson-Raybould, I also want to thank you for your presence here today. And I want to underscore that testifying like you have done today requires a lot of courage, and I appreciate that. Having said that, I have questions that may go in a different direction, but I'd like to get back to your motivation for your decision. There are some things you can't tell us, I understand that, but my first question is the reasons why you felt that it was not appropriate to come to an agreement with SNC-Lavalin after having looked at the criteria of Section 715 of the Criminal Code.
And the question, all I can say with respect to the question was that I did not believe, based on the Section 13 notice that I received from the Director of Public Prosecutions and the due diligence that I undertook, that it was appropriate with respect to SNC to issue a directive and intervene in the prosecution, to intervene in the discretion that was exercised by the Director of Public Prosecutions.
Est-ce que vous avez discuté?
Did you discuss the reasons why you felt that this was not appropriate to have such an agreement? Did you discuss this with the Prime Minister or someone else in the Prime Minister's office, for instance?
I did.
Est-ce qu'on peut savoir avec qui vous...
Can you tell us with who you discussed this?
I discussed it with the Prime Minister, with the Clerk of the Privy Council, with Elder Marquez, with Mathieu Bouchard, among other individuals, including the principal, well, indirectly, my Chief of Staff, Jessica Prince, discussed it with the Principal Secretary to the Prime Minister, as well as the Chief of Staff to the Prime Minister, as well as the Chief of Staff to the Minister of Finance.
Et je comprends que vous...
I understand that you feel that you can't tell us today what these motivations were, why you felt that there should not be any negotiation.
I felt at the time and made the decision that it was inappropriate for me as the Attorney General to interfere in the discretion that was exercised by the Director of Public Prosecutions with respect to SNC and the decision that was made to not enter into negotiations around a deferred prosecution agreement.
Merci beaucoup. Monsieur Fortin?
Mr. Fortin, I'm sorry, but you're 3 minutes. 3 hours and 3 3 hours and a half and you can't give me 30 extra seconds? I'll give you 30 seconds more. Just 30 seconds. So that everybody knows. I want to understand Ms. Wilson-Raybould's testimony. It seems to be important for all the citizens to understand that aspect of the situation. This is pretty surprising here. Now, I'm not saying your question isn't important. I'm just stating the fact that your 3 minutes are up. I'll give you 30 seconds more if you wish. Ms. Wilson-Raybould, 30 seconds. I'm sorry, but your decision not to intervene, was it based on one of the conditions of application under the criminal code for negotiations of a remediation agreement? That's under the sub judice rule. No, I'm sorry, it's not. I wasn't asking her what the reason was. I was wondering whether that's within the criteria. She can answer if she wants. Thank you, Mr. Chairman. I'll allow Madam Wilson-Raybould time to answer.
Thank
Merci,
you.
Madame Wilson-Raybould.
Mr. Weir.
Well, thanks very much for the opportunity, and Ms. Wilson-Raybould, thanks very much for your extensive and informative testimony. I'd like to ask you to expand a bit on the idea of separating the role of Attorney General from that of Minister of Justice. It seems that under our current system, the Prime Minister could choose to appoint two different people to those posts. Is that what you would recommend, or do you envision making the Attorney General an officer of Parliament, or somehow officially separating it from the government?
Well, I don't want to get too far in advance. I really hope that the committee will consider looking at studying this. I always try to look for ways to move forward. I think that it would be entirely appropriate for this committee to look at different models internationally. I mentioned the United Kingdom, where the Attorney General is not a member of Cabinet. The two hats that the Minister of Justice and the Attorney General wears here in our country are completely different, and I think there would be merit to talking about having those as two separate individuals. Obviously, after much discussion and study, the prerogative of the government of the time, what they would choose to do in that regard, and the Prime Minister.
Is that an idea you ever floated to the Prime Minister or to the Clerk of the Privy Council office?
I would say no, because I can't remember a concrete discussion where we had. But there have been times where I have raised the issue internally when I was the minister with individuals, and potentially I could have had conversations with other colleagues.
Okay. Now, you were asked about whether you supported deferred prosecution agreements, and I don't want to push that question again. I do want to ask, though, if you could describe what the ideal candidate for a deferred prosecution might be.
Well, I think that it's the tool of a deferred prosecution agreement and considerations that the Director of Public Prosecutions or prosecutors can take into account are delineated and articulated within the criminal code.
Okay. No, that's good for me.
Thank you so much. So I want to take this opportunity to thank Ms. Wilson-Raybould very much for her testimony. It's very much appreciated.
Thank you.
And now we are on Mr. Rankin's motion, and we've been asked for a short pause to consider discussion. So can I just say the meeting is suspended for 5 minutes? 5 minutes.